Welcome into the Cheeley Law Review. My name is Ben Burnett. Today, Bob and I are going to discuss the opening statement. Bob, what do you like about opening statements in the courtroom?
People love stories, and that's my chance to tell a story, to paint a picture of what they're going to hear at trial. It's a really incredible opportunity to connect with a jury. What you try to do is you try to take a complex set of facts and simplify it so that it's so clear to them that your client is entitled to justice based on what occurred. I love that part probably more than any other part because it's kind of like, in a baseball game, it's like just knock the leather off the ball on the first batter.
What are your goals? You said you like to use it to paint a picture and make really, really complex things in a story that an average person can understand. Talk to me about length, preparation. What makes a good opening statement in your mind?
The things that make a really good opening statement is, number one, keep it simple. Number two, it's got to include visuals. You can't just be words because people remember what you tell them, and if you show them what you're telling them at the same time, that's when they remember important concepts and important facts. And then the third thing that's really important about opening statement is basically, I love to tell the jury that we're involved in. I ask them in voir dire, which is jury selection. How many of you watch TV shows like CSI? Inevitably a lot of hands go up, and I ask them, what is it? I'll pick out 3 or 4 people and say, what is it you like about CSI? And they tell me, it's the whole problem solving, trying to take bits and pieces of evidence and put it together and figure out who did it. And, and so then I take what they say in jury selection, and assuming several of them wind up on the jury, I tell them that in opening statement that I'm inviting them to come on a journey with me, and we're going to do our civil version of CSI. This is not a criminal case, this is a civil case, but we're going to take and apply the same kind of things that they like about watching CSI, and I'm going to do my best to present to them the facts and the evidence here, and they're going to be the ones at the end of the case. The judge can't do it, I can't do it, the defense lawyer can't do it, but they will decide the facts, and they will decide who should prevail. And if the plaintiff is to prevail, as I say, I'm going to prove to you that my client should prevail, you're going to decide the amount of money, damages to be awarded. And so that really, I found, inspires jurors to really pay attention during the trial when they know that it's up to them to apply their common sense and the law that the judge is going to give them to determine who's right and how much compensation the verdict should be.
When you craft an opening statement, do you have a goal for length? Do you lose the attention span at a certain time? How do you keep them engaged in a process? Like if you set me there for 8 hours, how long can you expect me to pay attention?
I hardly ever go over an hour for opening statements. If you can't say it in an hour, actually if you can't say it in the first 5 minutes, in summary, you're probably going to lose people. It's attention span. So I like to keep it short, and as I said, I like to use visuals. I typically use a timeline. I use a PowerPoint on a timeline and put up one screen at a time, one slide at a time, and I talk the jury through it. And I'll give you a great example. I did this in a case involving breach of fiduciary duty. One business partner sued another, and tried this case in Florida in May of 2022, and it was a fairly complicated set of facts and tens of millions of dollars at issue. But I spent a lot of time working on this PowerPoint that was used had like 35 slides. But by the time that I got finished with that, I saw heads nodding on the jury, and I knew that they understood what the case was all about. Afterwards, at the end of the trial, I went back to that same timeline and PowerPoint and pulled out not all 35 slides, but maybe 5 or 6 of them. I said, you'll remember what I promised to you, ladies and gentlemen, in my opening statement that I would prove, and I did it. I proved these facts. It's just a way of showing the jury that in my opening contract with them, I told them what I would deliver, what I would prove, and then in closing argument, I show them that I fulfilled my contract to you, and I proved each one of these things. and here's the testimony from the trial that proved it.
This has been another episode of the Cheeley Law Review. See you next week, everybody.